we need to take care of the price as well. Now, Google Cardboard is something which is for 299 rupees, it's like about $15 or something. So that is something which could be probably the future for our world. Now, IP in VR, well, just like any other IP in any other part, it is important because it gives you a monopoly. It allows copycats to be out of the situation, keeps the infringers out, pretty much the standard stuff. But there are other things which are complex issues that arise around it. Once again, the IP involved, again, are traditional, but need to be applied in a more untraditional manner. So in this particular presentation, I will only be touching upon trademarks and hopefully on copyrights because it's going to take too much of time. So trademarks and virtual reality. Trademarks, as most of us know, is a brand, in this case an avatar, a character, anything that connects the character or that mark with the owner of the virtual reality, and it is used in the course of trade. Now, the way trademarks are used in VR, they can be used as avatars or characters which have been created, or objects that have been created by the users and the owners, or they can be third parties creating third-party marks used by the VR owner, or third-party marks used by VR users. VR owners are the people who provide the whole, say for Facebook provides Oculus Rift, so they are the owners. I am a user, so I can create my virtual world within it. I can create my own Nike shoe within it, and that is what a user's use of a trademark would be. I'm going to touch upon that. Now, there are usually two kinds of virtual realities. One where the content of the virtual reality, the virtual environment is created by the user, and then there is another one where the user is created by the owner. There are some very interesting virtual worlds. One is Second Life, which is what I will be touching upon today. Second is something called Sims, Active Worlds, and IMView. All of them are worlds where you can go in, socialize, interact, and do business. So since it's an IP conference, we are looking at business. We will be talking about business. These are some user-provided content. World of Warcraft, shows like Big Bang Theory have made it very popular for those who don't play such things. Second Life. Now, Second Life is a virtual world which was created, and it is something, even I became a part of it. I never did become immersed in it, but it is something which is quite interesting. It is a virtual world where people socialize, meet, and do trade. They have their own dollar called Linden Dollars. It's owned by a company called Linden Labs. These Linden Dollars can be purchased off exchanges, and real currency can be converted into Linden Dollars. So we are talking about real currency being changed into real money. Users are called avatars. Now, this Second Life has got a very, very vibrant economy. Over here, they can create, the users can create their own objects, they can create their own things, they can do anything that they want to do over there, and most importantly, they can retain the rights in whatever they have created. So this obviously opens up interesting trademark issues. Users can distribute and sell their creations. As of the last records, Second Life does not have too much of, have not disclosed a lot of data, but whatever little public information is available, there are 2.1 million items listed on the online marketplace. Now this is huge for anybody. Profits derived from renting land and services. Right now the economy is $165 million US dollars, which is pretty huge. This is in 2006, there was a avatar called Anish Chung. She converted her initial investment of barely $10 into $1 million from virtual world. So this is the capability of the virtual world. Major tech corporations have started putting their things into virtual world, and they've been doing it for the past 10 years. So it seems new, but it's pretty old. Obviously, there are even broadcasters who have put their stuff over there. Now, again on Second Life, in May 2007, there were this unauthorized usage which was happening in virtual world. 16 shops advertising Ferrari, 40 stores advertising Rolex and Chanel watches, more than 50 stores carrying Gucci, Prada, Ray-Ban and Oakley glasses. Hits in the virtual world on advertisements and classifieds were 160 hits for Gucci. Louis Vuitton was getting generated hits of 39. Nike was generating 186 hits. None of them have been authorized by any of the companies. There are iPods which are being sold over there, and they even sell unlicensed music to the virtual iPod from Michael Jackson to Gwen Stefani. There are shopping malls which have tons of real world brands being used and purchased. So there's only one case law which I could find, and that involves Taser versus Linden Labs, in which Taser is a company which makes that electric stun gun, which we must have seen in most of the movies and stuff. Taser sued Linden Labs for infringement of their brand because one of the avatars had created a virtual stun gun calling it Taser, and they were using that avatar to stun other avatars. So interesting. And there was also tarnishment because the avatar was selling these Taser guns right next to a pornographic shop. Nothing was decided. The Taser Incorporated withdrew the case. There was some settlement. Nobody knows what happened. The two questions which were to be answered were, what is the law around virtual representation of real life? Does it amount to tarnishment? I'll try to address this as succinctly as possible. Does this amount, virtual representation of real good in real life goods, amounts to infringement? The answer to that, probably from an Indian trademark perspective, would lie in the fact that the use of that registered trademark has to be in the course of trade. Now, course of trade is the key over here. It should be identical or deceptive, which is pretty much given. Goods and services for which the trademark is registered should be similar. Now, goods and services in the Indian law does not define goods to be virtual or non-virtual. So pretty much I would consider that the goods or services would be taking into account an inclusive way of looking at virtual goods as well. Plus, this use should render the use as being used as a trademark. Now the fact is, a person who is an avatar and using a brand of a third person, and I am in that second life, I will not assume that this brand belongs to Taser or Nike or Ray-Ban or anybody else. I know it does not belong to them. Would such an issue amount to a trademark infringement? So in India, obviously, we do not have any settled case laws. However, my understanding is if the use of such a brand is in the course of trade, be it a virtual world or a real world, it will amount to infringement. Dilution is a far more tricky situation. Tarnishment is a form of dilution. It is a far more tricky situation because virtual world mimics the real world, and they try to bring it as close to the real world as possible. Now, in real world, we do not know. You can have an Apple store, and right next to it, you might have a tobacco shop, which is not that appealing to someone else. So, in a real world, if something like this exists, we would not call it dilution, just because another person is right next to you. So dilution, tarnishment, erosion of brands is going to be a very tricky issue. Publicity rights, yes. The consumers may require, the avatars might require the person they are imitating, their permission. But again, is it being used for commercial purpose, or is it just for the user's own enjoyment? So tomorrow, if I want to be Brad Pitt in a virtual environment, it's just for me. I'm not making money off it. So would that amount to infringement? I think not. There are many other brand issues which arise. For instance, there could be a VR application. Most of the broadcasting companies are now doing it. Sporting events, films, concerts. Chris Milk, I think, is very popular in creating immersive concerts. So you can watch concerts as if you are sitting in a real concert. In that, there would be broadcasting issues. There are going to be other third-party brands. There are going to be many other things which are going to come in. Would such a thing amount to infringement or not? So probably the easiest way is the platform. In this case, say for instance, Oculus Rift, if it is showing you a sporting event, then it has taken permission from the right holders. Platforms can be content neutral and can be covered under the safe harbor provisions of Information Technology Act and whichever other corresponding acts in other parts of the world. Again, the question is it creating a false association between the brand and the platform owner or the user? This is something which I personally think is going to be very interesting in the near future. Rights in virtual property and content. Second Life, Anne Cheung has made her money on selling virtual property. Now, if content is created by the owner, unless it is obviously contracted otherwise, if I'm the user, I have created my property, it belongs to me. unless the terms and conditions of the platform say otherwise. Now, this is something which has to be decided. Does this VR, this virtual property, amount to a real world property? If the virtual property has no value, then it has no value any which way. So to who does this right belong? Probably laws will need to catch up with technology. There would be regulations, maybe real estate regulations, that actually deal with virtual rights. This is another point which is quite interesting, that talks about virtual rights in real worlds. Users create their own IP within the virtual world. Users may want to assert these rights when they in the real world. Now these rights have been created in a virtual world. Say for instance, I'm in Second Life, I create a right, I create my own brand over there, people are buying that brand, and somebody in real life starts copying that and selling that. What is the law around it? So traditional laws will apply, but there will be few twists around it. So for instance, in a case of a trademark, and if you look at it from an Indian perspective, a registration may be granted, maybe it might be enforceable, but if I'm trying to get a registration for a trademark, claiming use of that virtual brand in a virtual world, then I will not be able to show, the registry is probably going to say, show me the use of this brand in real world, and which is not decided. Does it amount to use or does it not amount to use? Consequently, maybe a VR owner will be forced to get into service class, which automatically limits his ability to take action against third parties. Again, copyright is another issue. Yes, it is a rendition, everything is original, but what is original if everything is based upon real life? So how much of it would be protected? Publicity rights. While as of today, publicity rights only protect natural people. What happens to an avatar who's a very famous avatar? His rights are being violated in real world. What is the rights around it? Possibly character laws would apply, maybe publicity rights or personality rights will apply, but that's an issue which has to be decided about a virtual right. I think I'm going to be very short on time, probably another 3 to 4 minutes. I'll try to finish off copyrights, though it is quite huge. I'll run through this. Copyrights practically subsist in original works of authorship. Virtual reality applications practically will always have copyright issues involved in them. Now, virtual reality is composed of works, which I'm going to call virtual works. Now, what is a virtual work? It is something, it could be a computer code that creates the virtual environment. It could be an audiovisual presentation. It could be a user interface with its own look and feel. It could involve interactive media. It could involve video recordings. It could be, the critical thing that would be required over here would be, it should be sufficiently permanent or stable to permit it to be perceived, reproduced, or communicated. Something I'm not going to be able to cover everything. Okay. Scope of protection of copyrights, infringement, fair dealings, and amendments to Act. I will not be able to cover everything. Probably I'll just cover some parts of it. Scope of protection is going to be in relation to the code and the non-computer program part of it. Existing laws should extend towards the virtual reality aspect as well. Important thing is, original expressions will be protected. Ideas alone cannot be protected. Now, what is an idea and what is an expression has been pretty well summed up by a Supreme Court judgment in India in 1972, and oddly enough, it still applies to most of the cases. Not oddly enough, I think it's a beautiful judgment, which basically says that there can be no copyright in an idea, historical, legendary fact, or any violation of a copyright in such cases is going to be confined to the form, manner, arrangement, expression of the idea by the author of the copyright work. According to me, this will apply squarely onto a virtual reality. What is original is going to be dependent upon, it's something which is independently developed. It has to be a little bit more than sweat or brow, but it has to be a little less than modicum of creativity. India follows a principle between modicum of creativity and sweat or brow. It does not have to be merely original. It needs to be a little bit more than original, which leads to somewhat different character being created.